Hello. Welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I'm the Third Circuit representative for the Young Lawyers Division Board of Governors. Today I have the pleasure of speaking with Joe Bodiford about discovery in criminal matters. Joe is a certified criminal trial lawyer. He is also certified in criminal trial advocacy by the National Board of Trial Advocacy. Joe, welcome.
Hi, good morning.
Good morning. How is a criminal case in discovery matters different than in civil?
Well, I think the biggest difference is that it's not mandatory. It's actually triggered by a defendant's desire to participate in the discovery process. Alternatively stated, that if the defendant decides not to participate, then the case goes to trial essentially by ambush. Everybody just shows up and puts all their stuff out there and sees what happens. But once the defendant triggers it, then there are obligations on both sides. The prosecutor has the obligation to disclose all information, including anything that could negate the guilt of the defendant. That's under Brady. And the defense has the obligation to disclose anything that's going to be used at trial. There's a critical difference there because if some negative information comes in that is not going to be used at trial, certainly the defense does not have any obligation to disclose that. But if the defense is going to get an expert witness who renders a report, even if that's not going to be used at trial, the current reading of the rule is that has to be disclosed. So as we've talked about in one of our other videos, be extremely careful when engaging an expert.
Okay. Is there anything that's off limits?
Yes, there's a couple things that are off limits in criminal discovery. Work product of certainly the prosecutors would be off limits. We are generally not going to get access to a law enforcement officer's notes, the handwritten notes that they make on scene that they ultimately type up. Motions can be done to ask the officers to preserve those if need be, but generally you're not going to get access to those. And the other thing that you will not get access to is the name of a confidential informant, hence them being confidential. But again, there's some specific situations in which, by motion, the government can be ordered to produce the name of the confidential informant. But again, don't do that, as we've talked about in a lot of our other videos, don't do that just willy-nilly. Think about it, because generally once that cannon is fired off, the ability to negotiate the case becomes very difficult.
Definitely. What if there is an actual discovery violation? What happens then?
Well, Florida is governed by a case. Richardson is the case, and essentially what it says is that if in the course of the trial, and the pre-trial, it's really governed more by the rule. That would be with motions to disclose and motions to compel and things like that. But once at trial, if something pops up, the case will stop, the trial will stop, and the judge will hold what's called a Richardson hearing. And the violator will be asked to prove why the violation is not willful, or is it indeed substantial, or is it willful and substantial? In other words, is it willful or inadvertent? Like, gosh, we just forgot to give this. We talked about it in a deposition. I told the prosecutor in an email we were going to have it. I just forgot to give them the fourth page of a four-page report. Oh, okay, well, here it is. What does it say? Well, it's the signature line where the person signed it. Okay, well, that's not really that willful, and it's certainly not substantial. However, standing up, a defense attorney standing up and just calling a witness that nobody's ever heard of, that's going to be a problem. So that's the balancing test. Is it willful and is it substantial?
All right, Joe, you've certainly had some very useful information for us. Thank you for joining us.
Thanks for having me.
Absolutely. And that concludes this video for Mentoring with the Masters. Thank you for watching.